had a public seminar today, and a great part of the seminar and an exciting part for me is the question and answer section. So I get to hear about person, the place, the circumstance, the question that the person has. So I try not to answer, or it's quite difficult to answer specific questions, but people will ask questions about revocable living trust, irrevocable living trust, pooled income trust, a regular trust. They ask all kinds of questions. Now, a question that I fielded today, and it's often an often repeated question, is if I have a will, why do I need to go to probate? If I have a will and I'm going to leave my house to my children, why isn't it automatic? Well, a will, even if legally done, especially if legally done and valid and perfectly executed, a will, a last will and testament, requires probate. It requires it. It's not a self-effectuating document. It's not, I pass away, my will takes over and then transforms the deed and changes the deed on the property to the kids. No, a will is a passport to the surrogate's court. It is a ticket to court. It is a required event. You have the will. What is probate? Why do we need probate? Why do we need to go to the court? Well, a chief reason, the main reason, the principal reason, the reason for probate is to take assets that are owned in your individual name and retitle them. So John Smith to the estate of John Smith. And then the estate of John Smith can transfer that property to the 3 children, to the 6 children, sell it to a person in the open market, on the open market. So the will requires you to file a petition for probate, and you need the permission and authority of the court to be named the executor, to be issued letters testamentary, and then those papers, the letters testamentary, allow you to change the deed from your individual name. It will allow your executor to change the deed from the individual name of the decedent to the name of the kids. We need it. A will requires probate.